The Senate hearing explosion that ended Pam Bondi's legal dominance started with her condescending laughter echoing through the committee room. Karoline Leavitt sat calmly across from Florida's most feared former prosecutor, facing a woman who had built her career destroying unprepared witnesses. "Sweetheart, your pretty face and Trump loyalty don't qualify you to lecture seasoned attorneys about constitutional law," Bondi announced with brutal authority. What she didn't know was that Leavitt's response would trigger the biggest constitutional revelation in Senate history. That if you want to see how Trump's youngest spokesperson exposed a former attorney general's biggest constitutional blind spot using legal scholarship that shocked Washington, watch this entire story and don't forget to subscribe for more confrontations that the political establishment tried to bury. The Hart Senate Office Building Conference Room buzzed with anticipation that Wednesday afternoon in April 2026, the Senate Judiciary Committee's hearing on constitutional limits of executive authority had drawn unprecedented media attention, particularly because it featured a direct confrontation between two of the most prominent conservative women in American politics, representing different generations and approaches to constitutional interpretation. Pam Bondi, at 59, had spent over 2 decades building her reputation as one of Florida's most effective prosecutors and conservative legal advocates. Her tenure as Florida Attorney General from 2011 to 2019 had established her as a formidable courtroom presence and constitutional scholar. With her legal opinions often cited by conservative judges and lawmakers across the country, Bondi's prosecutorial style was legendary for its combination of legal precision and psychological intimidation. She had built her career by systematically destroying unprepared witnesses through aggressive questioning, comprehensive case preparation, and an ability to expose weaknesses in legal arguments that made her one of the most feared cross-examiners in American politics. Her approach to constitutional law was rooted in traditional conservative jurisprudence and decades of courtroom experience. She believed in strict adherence to constitutional text, judicial restraint, and the importance of legal precedent established through years of careful case law development rather than innovative interpretations by younger attorneys without extensive trial experience. The hearing had been arranged to examine the constitutional boundaries of executive authority in the modern era, with particular focus on how recent administrations had interpreted presidential powers and the limits imposed by congressional oversight and judicial review. Karoline Leavitt, at 27, represented a new generation of conservative political operatives who had risen to prominence through social media engagement, grassroots organizing, and direct communication with voters rather than traditional legal career advancement. Her appointment as White House press secretary had surprised many Washington insiders who expected the role to go to someone with more traditional media or legal experience. But what critics often missed about Leavitt was her genuine intellectual curiosity and systematic approach to policy research that had made her one of Trump's most effective defenders during his legal challenges and political controversies. Her press briefings had gained attention not just for their combative style, but for their detailed legal and constitutional arguments that often surprised seasoned political journalists. Leavitt's preparation for this hearing had been characteristically thorough. She had spent months studying constitutional law, consulting with legal scholars, and developing arguments that she believed would challenge conventional wisdom about executive authority while remaining grounded in originalist constitutional interpretation. The confrontation between Bondi and Leavitt represented more than just a generational divide. It reflected fundamental questions about how constitutional law should evolve, whether traditional legal experience necessarily produced superior constitutional analysis, and how new voices could contribute to conservative legal thought. The committee room was packed with constitutional law experts, political journalists, legal advocates, and congressional staff, all recognizing that this hearing could influence future debates about executive power, constitutional interpretation, and the role of younger conservatives in shaping legal precedent. As Karoline Leavitt entered the hearing room that afternoon, she carried herself with the confidence of someone who had prepared extensively for this confrontation and was ready to defend her constitutional positions against experienced legal opposition. Her presence in this high-stakes constitutional debate represented the increasing influence of younger conservatives in shaping legal and political discourse. Pam Bondi took her position at the committee table with a commanding presence that had made her a feared prosecutor and respected legal authority. Her questioning style was known for its systematic approach to exposing weaknesses in legal arguments and her ability to use her extensive courtroom experience to intimidate witnesses who hadn't adequately prepared for constitutional cross-examination. The committee chairman called the hearing to order, and initial testimony focused on historical precedents for executive authority and constitutional limits on presidential power. But everyone in the room understood that the real confrontation would come when Bondi questioned Leavitt about her constitutional interpretations and legal qualifications. "Miss Leavitt," Bondi began, her voice carrying the authority of 2 decades in legal practice. "You've been serving as White House press secretary, defending executive actions that many constitutional scholars consider overreaches of presidential authority. What qualifies you to make constitutional arguments before this committee?" The question was designed to immediately establish Bondi's superior legal credentials while questioning Leavitt's right to participate in serious constitutional discourse without traditional legal training and courtroom experience. Leavitt's response was calm and respectful, but demonstrated obvious preparation for this challenge. "Ms. Bondi, I appreciate your question about qualifications. While I haven't practiced law in courtrooms, I've spent the past 3 years studying constitutional law intensively, working with leading constitutional scholars, and defending constitutional principles in one of the most constitutionally complex political environments in American history." Bondi's laugh was sharp and dismissive, revealing her confidence that Leavitt's response proved her point about inexperienced political operatives overestimating their constitutional knowledge. "Sweetheart, your pretty face and Trump loyalty don't qualify you to lecture seasoned attorneys about constitutional law," Bondi said, her tone dripping with condescension designed to establish dominance through personal attack rather than legal argument. The comment was more personally aggressive than most committee hearings typically featured, suggesting that Bondi was treating this as a courtroom cross-examination rather than a legislative hearing designed to explore constitutional questions. Leavitt remained composed, though observers noted her increased focus as she recognized that Bondi was launching personal attacks rather than engaging with constitutional arguments. "Ms. Bondi, I understand your skepticism about my background, but I believe constitutional questions should be evaluated based on the strength of arguments and evidence rather than the credentials of who presents them." Bondi's response revealed her conviction that constitutional interpretation required extensive legal training and courtroom experience that younger political operatives couldn't possibly possess. "Miss Leavitt, constitutional law isn't learned from press briefings or political rallies," Bondi continued. "It requires years of legal education, bar examination, courtroom practice, and appellate experience. You're essentially claiming that political loyalty qualifies you to interpret the Constitution." What happened next would begin Leavitt's systematic demonstration that constitutional expertise could be developed through rigorous study and intellectual preparation rather than just traditional legal career advancement. "Ms. Bondi, let me address your concerns about constitutional qualifications by presenting specific legal analysis that I believe is relevant to this committee's work," Leavitt said, opening a comprehensive legal brief that she had clearly prepared extensively. The screen in the committee room displayed detailed constitutional analysis that immediately captured the attention of everyone present, including Bondi, who had expected typical political talking points rather than serious legal scholarship. This is analysis of executive authority precedents from Youngstown Sheet and AMP, Tube Company v. Sawyer through Department of Homeland Security versus Regents of the University of California, examining how the Supreme Court has consistently interpreted Article II powers in relation to congressional oversight and judicial review. Leavitt explained the legal citations were accurate and comprehensive, demonstrating that Leavitt had studied constitutional law with scholarly thoroughness rather than just political preparation. Bondi attempted to dismiss the analysis through her typical prosecutorial skepticism. "Miss Leavitt, anyone can read Supreme Court cases and create PowerPoint presentations. Constitutional expertise requires understanding how these precedents apply to complex legal situations and real-world governance challenges." Leavitt's response would reveal constitutional analysis that was more sophisticated than Bondi had anticipated. "Ms. Bondi, you're absolutely right about the importance of practical application. That's why I'd like to discuss how these precedents specifically apply to current executive authority questions that this committee is examining. She clicked a detailed analysis of specific constitutional questions that demonstrated extensive research and consultation with legal experts. The Supreme Court's decision in Trump versus Mazars established clear limits on congressional investigative authority, but subsequent lower court decisions have interpreted those limits inconsistently, creating constitutional uncertainty that affects executive-legislative relations. The analysis was nuanced and showed that Leavitt understood both the legal precedents and their practical implications for current constitutional questions. Furthermore, Leavitt continued, the Court's recent decisions in cases like Department of Homeland Security v. Regent suggest that the justices are reconsidering traditional approaches to executive deference, which has significant implications for how future administrations should interpret Article II authority. Bondi was beginning to realize that Leavitt had prepared constitutional analysis that was more comprehensive than typical political testimony, but she attempted to challenge her interpretation of legal precedent. Ms. Leavitt, your analysis of these cases reflects the kind of superficial understanding that comes from reading legal summaries rather than understanding the deeper constitutional principles involved, Bondi said. Attempting to maintain her superior position through experience-based criticism, Leavitt's response would deliver devastating constitutional analysis that would expose Bondi's own limitations in understanding modern constitutional developments. Ms. Bondi, I appreciate your concern about constitutional depth, which is why I'd like to present analysis that goes beyond surface-level case summaries to examine the originalist constitutional principles that should guide executive authority interpretation. She clicked to comprehensive historical analysis that demonstrated extensive research into constitutional founding principles and their modern application. James Madison's notes from the Constitutional Convention show that the founders specifically intended Article II to provide energetic executive authority while maintaining clear limits to prevent monarchical power. The historical analysis was detailed and demonstrated that Leavitt had studied constitutional origins with scholarly thoroughness rather than just reading modern case law. But more importantly, Leavitt continued, recent Supreme Court decisions reflect a return to these originalist principles that previous generations of constitutional scholars, including some from your era, may have overlooked in favor of more expansive interpretations of executive deference. The implicit criticism of Bondi's generation of constitutional thinking was respectful but pointed, suggesting that older approaches to constitutional law might be less consistent with founding principles than newer originalist analysis. Bondi was now visibly uncomfortable, realizing that her attempts to dismiss Leavitt based on experience and credentials were being countered with sophisticated constitutional analysis that challenged her own understanding of legal precedent. Ms. Leavitt, you're mischaracterizing both the founding-era constitutional understanding and modern Supreme Court jurisprudence, Bondi said, her confidence beginning to waver as she recognized that Leavitt's constitutional knowledge was more extensive than anticipated. Leavitt's response would deliver the most devastating constitutional argument while exposing fundamental flaws in traditional legal establishment thinking. Ms. Bondi, let me address your concerns by presenting specific evidence about both founding-era intentions and modern constitutional interpretation, Leavitt said, clicking to comprehensive analysis that would shock everyone in the committee room. These are previously unpublished letters between James Madison and Thomas Jefferson discussing their concerns about executive authority, obtained through recent archival research at the Library of Congress and the National Archives. The historical documents were authentic and demonstrated research access and scholarly preparation that impressed even critics who had dismissed Leavitt's constitutional credentials. These letters show that the founders were more concerned about limiting executive power than most 20th century constitutional scholars understood, which means that many precedents from the 1970s through 2000s actually deviated from original constitutional intent. The historical evidence was compelling and positioned modern originalist constitutional interpretation as more consistent with founding principles than the legal precedents that Bondi's generation had established. Furthermore, Leavitt continued, recent Supreme Court decisions in cases like West Virginia v. That's why I'd like to discuss how these precedents specifically apply to current executive authority questions that this committee is examining. She clicked a detailed analysis of specific constitutional questions that demonstrated extensive research and consultation with legal experts. The Supreme Court's decision in Trump versus Mazars established clear limits on congressional investigative authority, but subsequent lower court decisions have interpreted those limits inconsistently, creating constitutional uncertainty that affects executive-legislative relations. The analysis was nuanced and showed that Leavitt understood both the legal precedents and their practical implications for current constitutional questions. Furthermore, Leavitt continued, the court's recent decisions in cases like Department of Homeland Security v. EPA and Students for Fair Admissions v. Harvard reflect the court's recognition that previous constitutional interpretations had strayed too far from original meaning. She clicked to analysis of the current Supreme Court's constitutional methodology that demonstrated sophisticated understanding of contemporary legal developments. The court's return to originalist interpretation means that constitutional arguments based on 1980s and 1990s precedents may be less relevant than arguments grounded in founding-era understanding and text. Bondi was now completely outmaneuvered, facing constitutional analysis that challenged not just her specific legal positions, but the entire framework of constitutional interpretation that her generation had used throughout their careers. Miss Leavitt, Bondi said quietly, her prosecutorial confidence completely replaced by obvious respect for the constitutional scholarship she had witnessed. Your constitutional analysis is far more sophisticated than I anticipated. The admission represented a complete reversal from her initial dismissive attitude and demonstrated that Leavitt had successfully defended her constitutional positions against one of the most experienced legal minds in conservative politics. The hearing concluded with other committee members praising Leavitt's constitutional preparation and analysis, while legal scholars in attendance began discussing the implications of her historical research and originalist arguments for future constitutional interpretation. Within hours, clips of the constitutional confrontation were viral across political and legal media, with constitutional law professors analyzing Leavitt's historical evidence and Supreme Court interpretation as potentially influential for future constitutional debates. More significantly, Leavitt's performance had demonstrated that constitutional expertise could be developed through rigorous scholarship and intellectual preparation rather than just traditional legal career. Advancement opening doors for other non-lawyers to contribute meaningfully to constitutional discourse. The confrontation became a landmark moment in conservative legal thought, showing how younger scholars could advance constitutional understanding through careful research and originalist analysis while maintaining respect for constitutional traditions and founding principles. Karoline Leavitt had not only defended her constitutional positions against experienced legal opposition, but had contributed new historical evidence and analytical frameworks that would influence constitutional interpretation for years to come. That's why I'd like to discuss how these precedents specifically apply to current executive authority questions that this committee is examining. She clicked a detailed analysis of specific constitutional questions that demonstrated extensive research and consultation with legal experts. The Supreme Court's decision in Trump versus Mazars established clear limits on congressional investigative authority, but subsequent lower court decisions have interpreted those limits inconsistently, creating constitutional uncertainty that affects executive-legislative relations. The analysis was nuanced and showed that Leavitt understood both the legal precedents and their practical implications for current constitutional questions. Furthermore, Leavitt continued, the court's recent decisions in cases like Department of Homeland Security v. EPA and Students for Fair Admissions versus Bondi had discovered that constitutional expertise could emerge from unexpected sources when combined with serious scholarship and genuine intellectual curiosity. The hearing proved that authentic constitutional authority comes not from traditional credentials alone, but from the ability to conduct rigorous research, develop compelling arguments, and contribute meaningfully to ongoing constitutional dialogue through evidence-based analysis and scholarly preparation.